irresponsible procreative conduct outside of that marriage. Outside of that marriage. That's the marital norm. And so society has an interest in seeing a 55-year-old couple that just as it has an interest in seeing any heterosexual couple that intends to engage in a prolonged period of cohabitation to reserve that until they have made a marital commitment, so that should that union produce any offspring, it'll be more likely that that child or children will be raised by the mother and father who brought them into the world.
Mr. Cooper, we said that somebody who's locked up in prison and is not going to get out has a right to marry, has a fundamental right to marry. No possibility of procreation.
Your Honor is referring, I'm sure, to the Turner case, and I think that, with due respect, Justice Ginsburg, way overreads Turner against Safley. That was a case in which the prison at issue, and it was decided in the specific context of a particular prison, where there were both female and male inmates, many of them minimum security inmates. It was dealing with a regulation, Your Honor, that had previously permitted marriage in the case of pregnancy and childbirth. The court here emphasized that among the incidents of marriage that are not destroyed by that, at least that prison context, was the expectation of eventual consummation of the marriage and legitimation of children.
Thank you, Mr. Cooper.
Thank you, Mr. Chief Justice.
Mr. Olson.
Thank you, Mr. Chief Justice, and may it please the Court. I know that you will want me to spend a moment or two addressing the standing question, but before I do that, I thought that it would be important for this Court to have Proposition 8 put in context. What it does, it walls off gay and lesbians from marriage, the most important relation in life, according to this Court, thus stigmatizing a class of Californians based upon their status and labeling their most cherished relationships as second-rate, different, unequal, and not okay.
Mr. Olson, I cut off your friend before he could get into the merits, so I think
I was
it's
trying
only fair.
to avoid that, Your Honor.
I know you. I think it's only fair to treat you the same. Perhaps you could address your jurisdictional argument.
Yes, I think that our jurisdictional argument is, as we set forth in the brief, California cannot create Article III standing by designating whoever it wants to defend the state of California in connection with ballot.
But this is not whoever it wants. These are 5 proponents of the measure, and if we were to accept your argument, it would give the state a one-way ratchet. The state could go in and make a defense, maybe a half-hearted defense of the statute, and then when the statute is held invalid, simply leave. On the other hand, if the state loses, the state can appeal. So this is a one-way ratchet that favors the state and allows governors and other constitutional officers in different states to thwart the initiative process.
That's the way the California Supreme Court saw it with respect to California law. The governor and the attorney general of California are elected to act in the best interests of the state of California. They made a professional judgment given their obligations as officers of the state of California. The California Supreme Court has said that proponents, and by the way, only 4 of the 5 are here. Dr. Tam withdrew from the case because of many things he said during the election campaign.
Well, Mr. Olson, is it your position that the only people who could defend a law that's adopted in California through the ballot initiative are the Attorney General and the Governor, so that if the Attorney General and the Governor don't like the ballot initiative, it will go undefended?
I don't think it's quite that limited. I think one of your colleagues suggested that there could be an officer appointed. There could be an appointee of the State of California who had responsibility, fiduciary responsibility, to the State of California and the citizens of California to represent the State of California along.
Who would appoint him? The same governor that didn't want to defend the plebiscite?
Well, that happens all the time, as you recall, in the case of well, let's not spend too much time on independent counsel provisions, but the government of the State of California frequently appoints an attorney where there's a perceived conflict of interest. That person would have responsibility to the State and might have responsibility for the attorney's fees.
I suppose there might be people out there with their own personal standing, someone who performs marriages and would like that to remain open to everyone, but would prefer not to perform same-sex marriages. Or other people. We seem to be addressing the case as if the only options are the proponents here or the State. I'm not sure there aren't other people out there with individual personalized injury that would satisfy Article 3.
There might well be in a different case. I don't know about this case. If there was, for example, this was an initiative measure that allocated certain resources of the State of California and the people, maybe it was a binary system of people got resources and other people didn't get resources. There could be standing. Someone would show actual injury. The point, I guess, at the bottom of this is the Supreme Court, this Court, decided in Raines versus Byrd that Congress couldn't specify members of Congress in that context, even where the measure depleted or diminished powers of Congress.
The states are not bound by the same separation of powers doctrine that underlies the federal Constitution. You couldn't have a federal initiative, for example. They're free of all that. So start from the proposition that a state has standing to defend the constitutionality of a state law beyond dispute. Question then is, who represents the state? Now, in a state that has initiative, the whole process would be defeated if the only people who could defend the statute are the elected public officials. The whole point, you know this better than I do because you're from California, the whole point of the initiative process was to allow the people to circumvent public officials about whom they were suspicious. So if you reject that proposition, what is left is the proposition that the state law can choose some other person, some other group, to defend the constitutionality of a state law. And the California Supreme Court has told us that the plaintiffs in this case are precisely those people. So how do you get around that?
That's exactly what the California Supreme Court thought. The California Supreme Court thought that it could decide that the proponents, whoever they were, and this could be 25 years after the election, it could be one of the proponents, it could be four of the proponents, they could have an interest other than the state because they have no fiduciary responsibility to the state. They may be incurring attorney's fees on behalf of the state or on behalf of themselves, but they haven't been appointed. They have no official responsibility to the state. And my only argument, and I know it's a close one, because California thinks that this is the system, the California Supreme Court thought that this was a system that would be a default system. I'm suggesting from your decisions with respect to Article 3 that takes more than that under.
Mr. Olson, I think that you're not answering the fundamental fear. And so, the amici brief that sets forth this test of fiduciary duty doesn't quite either. The assumption is that there are not executive officials who want to defend the law. They don't like it. No one's going to do that. So how do you get the law defended in that situation?
I don't have an answer to that question unless there's an appointment process either built into the system where it's an officer of
So why isn't this viewed as an appointment process that the ballot initiators have now become that body?
And that's the argument.
Your argument.
That's the argument our opponents make. But it must be said that it happens all of the time, that federal officials and state officials decide not to enforce a statute, to enforce a statute in certain ways. We don't then come in and decide that there's someone else ought to be in court for every particular.
Well, what the brief says is that you first can appoint people. It's not just that you appoint them. It's that the state's interest, when it defends a law, is the interest in executing the law of the state. So all you have to do is give a person that interest. But when a person has the interest of defending this law, as opposed to defending the law of the State of California, there can be all kinds of conflicts, all kinds of situations. That's what I got out of the brief. So give the person that interest. And that, they say, is what's missing here. And you'll say, I mean, that's here, and you say it's missing here. Why is it missing here?
It is what is missing here, because you're not an officer of the State of California. You don't have a fiduciary duty to the State of California. You're not bound by the ethical standards of an officer of the State of California to represent the State of California. You could have conflicts of interest. And as I said, you could be incurring enormous legal fees on behalf of the State when the State hasn't decided to go that route.
You should feel free to move on to the merits.
Thank you, Your Honor. As I pointed out at the outset, this is a measure that walls off the institution of marriage, which is not society's right. It's an individual right that this Court again and again and again has said the right to get married, the right to have the relationship of marriage is a personal right. It's a part of the right of privacy, association, liberty, and the pursuit of happiness. In the cases in which you've described the right to get married under the Constitution, you've described it as marriage, procreation, family, other things like that. So the procreation aspect, the responsibility or ability or interest in procreation is not a part of the right to get married. Now,
I'm not sure, counsel, that I'm not sure that it's right to view this as excluding a particular group. When the institution of marriage developed historically, people didn't get around and say, let's have this institution, but let's keep out homosexuals. The institution developed to serve purposes that by their nature didn't include homosexual couples. It is, yes, you can say that it serves some of the other interests where it makes sense to include them, but not all the interests. And it seems to me, if your friend argues on the other side, if you have an institution that pursues additional interests, you don't have to include everybody just because some other aspects of it can be applied to them.
Well, there's a couple of answers to that, it seems to me, Mr. Chief Justice. In this case, that decision to exclude gays and lesbians was made by the State of California.
Oh, that's only because Proposition 8 came 140 days after the California Supreme Court issued
that's right.
Decision. And don't you think it's more reasonable to view it as a change by the California Supreme Court of this institution that's been around since time immemorial?
The California Supreme Court, like this Supreme Court, decides what the law is. The California Supreme Court decided that the equal protection and due process clauses of that California Constitution did not permit excluding gays and lesbians from the right to get married.
You've led me right into a question I was going to ask. The California Supreme Court decides what the law is. That's what we decide, right? We don't prescribe law for the future. We decide what the law is. I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791, 1868, when the 14th Amendment was adopted, sometime after Baker, where we said it didn't even raise a substantial federal question. When did the law become this?
I may answer this in the form of a rhetorical question. When did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate
schools? Easy question,
schools?
I think, for that one. At the time that the Equal Protection Clause was adopted. That's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional?
When the California Supreme Court faced the decision, which it had never faced before, does excluding gay and lesbian citizens who are a class based upon their status as homosexuals, is it constitutional?
That's not when it became unconstitutional. That's when they acted in an unconstitutional manner. When did it become unconstitutional to prohibit gays from marrying.
Then they did not assign a date to it, Justice Scalia, as you know. What the Court decided is a case that came before.
I'm not talking about the
this
California
practice.
Supreme Court. I'm talking about your argument. You say it is now unconstitutional.
Yes.
Was it always unconstitutional?
It was constitutional when we, as a culture, determined that the sexual orientation is a characteristic of individuals that they cannot control.
I see. When did that happen? When did that
There's
happen?
no specific date in time. This is an
Well, how am I
science-
supposed to know how to decide a case?
Because
then?
the case
you
that's
can't give me
before
a date when the Constitution
case that's before you
changes.
today, California decided, the citizens of California decided, after the California Supreme Court decided that individuals had a right to get married irrespective of their sexual orientation in California, and then the Californians decided